Well, I don't know what will happen now. We've got some difficult days ahead. But it really doesn't matter with me now, because I've been to the mountaintop.
Hey guys, we're going to do civil rights in this lecture. 10 minutes on civil rights. Definitely not enough time, but hopefully enough time to give you some insight into some of the multiple choice and enough time for you to scratch together a thematic essay to help you pass and hopefully learn a little bit in the meantime. Civil rights, of course, refers to rights of citizens that they feel are being denied, groups. We usually associate it with African Americans, but of course other groups claim discrimination as well, whether we're talking about Hispanic Americans, gay Americans, handicapped Americans. Different groups at different times in American history to this day claim that the government or groups are violating their civil rights. Now, one of the amendments you're going to hear me talk a lot about today or in this lecture is the 14th Amendment. It might be my favorite one. But really quickly, the concept of the 14th, which I've explained in the Judicial Review lecture, is that no state shall deny equal protection under the law. In effect, this kind of nationalizes different aspects of the Bill of Rights. And the Supreme Court has expanded those rights in the Warren Court and other areas to take that 14th and give us, the rating of suspects' rights or abortion rights or getting a lawyer if you can't afford one or, exclusionary rule in Mapp versus Ohio or whatever. That 14th Amendment is really the amendment that civil rights pioneers hang their hat on. And again, even current day, it would be people that believe that gay marriage should be constitutional claim that not allowing it is in a violation of the 14th Amendment. No state shall deny equal protection under the law. And anybody that's opposed to that, that's fine, and you're allowed to do that, and I'm allowed to do what I'm going to do, but you have to deal with those words of equal protection for all. And that's what brings us to African Americans, which is really the base of this lecture. So really quickly, we know 14th Amendment was a part of Reconstruction. When the Reconstruction ends, the 14th Amendment, which really I see as a tiger, as a federal government tiger to enforce, citizenship and voting rights for black people, becomes a toothless tiger. And that's the court case that's always on the exam, Plessy versus Ferguson. Now, we usually think of civil rights cases as, like in Brown versus Board, as the school case. The case, like the school, it could be anything. Remember, Jim Crow segregates everything. From the water fountain to the movie theater to the library to to the bus to the train to the hotel to the whatever. Everything's segregated. So really, what is being segregated isn't the heart of the question. Is segregation constitutional? And in Plessy, Homer Plessy in Louisiana challenged a law called the Separate Car Act, which was designed, of course, on railroads to keep blacks and whites in separate cars. He's kind of like the Rosa Parks of 1895. When he's arrested, he is basically fighting that arrest or that conviction on the grounds that the law was unconstitutional. The law, the Separate Car Act, was in violation of the 14th Amendment. So in Plessy, the court has to deal with those words. That's why I say, whatever you're for or against, you got to live with those words. And this is their way out. And I think it's a cop-out. But what they come up with is, separate isn't necessarily not equal. Separate's not equal. Separate's equal. Meaning that just because something's separated doesn't mean that it's unequal. That, if we use an example today, it would be like girls' and boys' bathrooms. They're separate, but they're equal in the sense that they're both cleaned by the same people and they're both treated the same by, the administration. So by saying separate's equal and kind of looking the other way, they're kind of allowing for Jim Crow to continue. And that's, of course, what happens. Plessy versus Ferguson is a case which legalizes Jim Crow in the eyes of the federal government, which takes the teeth out of the tiger of the 14th Amendment. Checking my time really quick. Two civil rights leaders that are on the test that are early on in African-American history, there's lots, guys, again, whole courses we're doing in 10 minutes here, are Booker T and W.E.B. I wish I had the poem in front of me, but there's a great poem called Booker T and W.E.B. And in parts of the poem, Booker T says things like, all you who shout about civil rights, and, oh man, I'm not doing good today, don't you grouse but work and save and buy a house. That Booker T was really about civil rights later. He was for civil rights, but the founder of the Tuskegee Institute was more interested in African Americans lifting themselves up than fighting for civil rights. Going to school and a vocational school, getting a basic skill, putting food on the table, and integrating into American society where whites would allow for civil rights down the road. On the other side of that equation is W.E.B. Du Bois. And W.E.B. would say things like, what good, it doesn't matter how much cash you got. Wait. A rope is as tight, a fire is as hot, no matter how much cash you got. And that concept is the idea that there's racism here. And civil rights aren't going to kind of walk up and jump in our pocket. That we have to fight for civil rights. And I don't mean like that. I mean legally. And W.E. Du Bois, the first African American to graduate from Harvard University, is the founder of the Niagara Movement, which later will become the NAACP, the National Association for the Advancement of Colored Persons. And that's the legal arm of this fight. That will be the lobby group that's responsible for Brown versus Board. So again, you want to know the difference between Booker T, who I always see in my head as like kind of overalls and a shovel, and W.E.B., who I always see in a bow tie with a briefcase. The idea of fight now legally, work now, rights later, but switched around. Nevertheless, we're moving on. The next big legal challenge comes in 1954 in Brown versus Board of Education, Topeka, Kansas. And again, this is really like Plessy Part 2. It's not really what we're discussing that is separate. It's the idea of separateness and whether that violates the 14th Amendment. So the court's going to try it again, some more judicial review, and they're allowed to do that. They're allowed to look over their shoulder at previous decisions and decide we've changed our mind. So in Topeka, Kansas, like in most cities and all cities in the South, blacks and whites went to separate schools. So Linda Brown is challenging that based on the idea that, no state shall deny equal protection under the law, and I'm being treated differently. So, I hate shortcutting anything. Of course, Brown versus Board, I shouldn't shortcut. But the court eventually rules separate is not equal. And it's not only the physical difference of separateness that they're talking about. And they do bring that up, that the books and the teachers and the funding and all of that, and the physical location and all of that. But actually the psychological separation. There's a famous experiment that they brought up where a teacher treated the blue-eyed and brown-eyed children differently. And we saw psychological changes in the group that was being discriminated against. So the court is basically putting the teeth back into the 14th Amendment. Of course, we're going to need enforcement, and we're going to need new laws, and we're going to need things to change it. It's not going to happen overnight. But Brown is the beginning of the end of Jim Crow. And Brown is really the culminating idea of starting the civil rights movement. The civil rights movement is built on the idea of civil disobedience. The Gandhi Idea. One of the first civil rights pioneers in the modern era, in the 1950s, is Martin Luther King. And most of you know kind of the story of Martin Luther King. But Martin Luther King was a Christian minister who was a member of the group, the Southern Christian Leadership Council. And they adopted boycotts and marching and kind of being peaceful but visible in order to change the system of Jim Crow. It starts with Montgomery, the Montgomery bus boycott, and Rosa Parks. Sometimes I just want to pound into people's head. Rosa Parks wasn't just tired that day. Like, I'm tired, I'm going to sit down. No, it was a planned event. She was a member of the NAACP. I see her almost like a spy, going to the Soviet Union to help the country. Where, it really devalues, I think, her contribution to American history. So, through the Montgomery bus boycott, which is successful, through marching, through other groups like CORE, the Congress of Racial Equality, and riding buses through the South, the Freedom Rides, or the Students for Nonviolent Courting Committee called SNCC, who led sit-ins and like Woolworths in the South. And really the concept, there's a lot of little events, Selma, and not little, they're big events, but the overriding concept that I have to finish in 60 seconds is that the reason it works, turning the other cheek and all that, and being peaceful and Gandhi and peace man, is because crap doesn't stink until it's in your backyard. That thesis. That when people see the truth, when people see people getting hit with billy clubs or kids getting, dogs attacked, they turn on the abusers. And that's what leads eventually to the 1963 March on Washington and enough public pressure to get Congress to change the law, to enforce the 14th in a sense. After the death of JFK, LBJ, Lyndon Baines Johnson, starts pressure in Congress again, and we get the 1964 Civil Rights Act. Make sure you know 1964 Civil Rights Act bans public discrimination. The 1965 Voting Rights Act, which is going to regulate elections in the South and have people that are going to watch over to make sure people vote. And remember, in Jim Crow, we had literacy tests and grandfather clauses and poll taxes. All that's going to end. 24th Amendment ends poll taxes. There's stuff that I forgot. Oh my gosh, I'm done. Affirmative action, reverse discrimination, Baki versus